I will not walk away from these Americans, and neither should the people in this chamber.
I've been covering the Supreme Court now for many years, and I have never seen a case ascend from the lower courts with such momentum. Within days of the bill's passage, almost half of the 50 states had filed suit in a federal court. And now, just 2 years later, the Supreme Court is preparing for 3 days of oral arguments. Most cases before the court get only an hour of oral argument. This case will have 6, a record for the modern era. I know public opinion polls continue to show that a majority of Americans think the health care law is unconstitutional, that it's a gross overreach of federal power, and the Supreme Court will strike it down. But I also know that within the legal community, even among stalwart conservatives, there is a strong feeling that whatever you may think about the law as a matter of public policy, it falls well within the constitutional powers of Congress. I wanted to know why the disconnect. How did we get here? And what can we really expect from the Supreme Court? So I made a list of lawyers, scholars, and politicians from all sides of the issue. To my surprise, almost all of them were eager to talk.
Congress does not have unlimited power under the Constitution. The structure of the Constitution sets up a limited government, and the real question in the case is how limited.
Oren Kerr is a rising star in the conservative legal world. A law professor at George Washington University, he advised Texas Republican Senator John Cornyn during one of President Obama's Supreme Court nominations. And he's a featured blogger on the influential conservative libertarian legal site, The Volokh Conspiracy. In short, he's the kind of guy who you'd probably think would feel the Obama healthcare law is clearly unconstitutional. But he doesn't. In fact, he doesn't even think it's a close call. Did it occur to folks in the legal establishment that this was going to be such a monumental issue in challenging the health reform?
It was pretty clear early on that challenges were going to be filed, but it was not widely thought that the challenges would go anywhere. That was really a surprise.
Now, I know you're a law professor and not a political, pundit, but is there a way in which these ideas, these basic ideas of freedom and states' rights and government overreach really did become a sort of stand-in for a lot of anxieties that people were feeling anyway?
I think these constitutional arguments captured the way at least one half of the political spectrum was thinking about the federal government. It really galvanized a movement. It created a legal argument, a constitutional argument around an instinct shared by a lot of people that the federal government had just become too intrusive and that this law was just a step too far.
The debate about the constitutionality of the healthcare law has centered around what is known as the Commerce Clause, found in Article 1, Section 8 of the U.S. Constitution. It says that Congress has the power to regulate commerce among the several states. And what everyone's waiting to see is how the Supreme Court will interpret that phrase in this case.
There's a long history of Supreme Court cases answering how far can the government go? And as we know from the fact that our federal government is so big, the current Supreme Court says the answer is pretty far. And so the issue in this case really boils down to, does this law go too far? Does this law extend so far that it essentially amounts to unlimited government, which should be unconstitutional, or are there limits on the scope of federal power that encompass this law, and in fact this law is within the Commerce Clause power, is within the scope of federal power under constitutional law? Over time, the Supreme Court has adopted a broader and broader approach to what interstate commerce means. And under current constitutional principles, as long as it involves commerce, as long as Congress is trying to regulate something involving commercial transactions, then generally Supreme Court cases say it's okay.
Ultimately, whether a law is upheld as constitutional or whether it's struck down is in the hands of the 9 justices of the United States Supreme Court. Those who currently wear the robes are often divided into 3 categories. There are the 4 justices appointed by Democratic presidents, Ruth Bader Ginsburg, Stephen Breyer, Sonia Sotomayor, and Elena Kagan, the so-called liberal wing of the court. The 4 justices generally considered to be the bedrock conservatives Antonin Scalia, Clarence Thomas, Samuel Alito, and the Chief Justice, John Roberts, and the Ninth Justice, Anthony Kennedy, who is seen as an important swing vote. Lawyers with a case before the court will often write their legal briefs to try to sway Kennedy, something Orrin Kerr saw firsthand when he clerked for him. Justice Kennedy is held out, rightly or wrongly, as being the deciding party in this case, in every case. I mean, I think we often think about the Supreme Court as two teams of four, and then Justice Kennedy's big pulsing brain that determines every outcome. Do you see strands, at least in the briefs or the way the case has been framed, that look to you like explicit attempts to talk to Justice Kennedy?
Actually, the briefs in this case are quite different. Some of them are addressed to Justice Scalia, some of them are addressed to Chief Justice Roberts, some of the arguments are just addressed to the court as a whole. Justice Kennedy is probably not the fifth vote in this case. He might be. But you have to understand the math that we start out with this case. So everyone agrees that the four liberal-leaning justices, the four justices nominated by Democratic presidents, are going to vote to uphold the statute. There's almost no disagreement on that question. A lot of people also start off with the assumption, which I think is correct, that Justice Thomas is very likely to vote to strike down the statute based on his writings on the Commerce Clause. So that means there are four justices in play, and the challengers to the statute need all four justices in order to get to five. 5 votes, you win. So it's a little bit like a World Series game where a team is 3 games down. They need to win all 4 games in order to win the series. So for the challengers, they have no justices to spare. They need to win Kennedy, they need to win Alito, they need to win Roberts, and they need to win Scalia. They need to win all 5 of the conservative-leaning justices in order to have the statute struck down.
If you've got it, watch it. If you don't, call your TV provider to get HDNet today.